Thanks for giving me the opportunity to present the summary of my paper in this form. I'm sorry I can't be at the conference and listen to the papers and get comments from you directly on this, but I hope this presentation will be useful. I'm going to talk about emergency law as administrative law, and I want to distinguish that between from discussions of the regulation of counterterrorism policy, which focus on issues about the relationship between constitutionalism and emergencies. As Mary Duziak recent work, Wartime, confirms, counterterrorism policy is today better seen as dealing with a relatively permanent condition, not a transient event. In this light, counterterrorism policy could perhaps be better regulated, not through a distinctive law of emergencies, but rather through ordinary administrative law. As conceptualized in the United States, and my discussion is confined to the United States because of my lack of knowledge about administrative law and other systems, administrative law establishes a regime of legality that acknowledges first the role that expertise, here expertise in national security policy, plays in developing lawful regulation. Second, the interplay between the administrative bureaucracy and the political branches, especially the legislature, in shaping policy. And third, the necessary but limited role of the judiciary in ensuring that policy developed by administrative agencies does not threaten fundamental rule of law values. I'm going to argue that many, though not all, well-established elements of modern U.S. administrative law can satisfactorily address many, though not all, of the legality issues raised by counterterrorism policy. The term satisfactorily, of course, conceals much. I mean that those elements provide an allocation of decision-making authority among the executive, legislatures, and courts that's probably better than any other allocation realistically achievable through institutional design. That allocation might place looser constraints on the exercise of power than might be normatively desirable in the abstract. But just as emergency power is exercised in the real world, so too must constraints on its exercise be ones that can be implemented in the real world. Duziak's book reminds us that time is one of the dimensions along which we differentiate between the normal and the exceptional. But she argues war is an enduring condition, not a passing event, and so, she suggests, we ought to think of war as the normal and peace as the temporal exception. If that's right, we also ought to think differently about the constitutional implications of war. If war is an enduring condition, the metaphor of fixed stars that govern our constitutional order has to give way. Instead, we have something like a blurry ring with uncertain boundaries. And I should note, we're in the United States involved in many metaphorical wars on cancer, on crime, on drugs, on terror, formerly on poverty, and notably arguments about government power and individual rights in all of these areas have the same structure as arguments of about power and rights in connection with counterterrorism. In each, proponents of the war argue that the exigencies of the struggle require that we rethink previously held ideas about power and rights. The point's obvious and banal, I think, in connection with wars on crime and terror. Consider Zakharov and Tildas's formulation of the distinction between wartime and peacetime. It should turn on whether there are times of heightened risk of physical safety of citizens. Now, that's precisely how proponents of the war on crime characterize the situation facing the United States. Richard Nixon's campaign for the presidency in 1968 emphasized that the Warren Court had gone too far in weakening the peace forces as against the criminal forces. If war is a condition rather than a time, how should we think about its constitutional dimensions? Duziak suggests that our conventional way of thinking about war must be reconsidered because the conventional way is to say to ourselves, we can do things now during wartime that we didn't do then before the war and won't do later after the war. But of course, there is no now or then, no sooner or later. That's either a mistake or, more worrisome, a trap. Now, I want to suggest an alternative way of thinking through ordinary administrative law. Let me use the example of the regulation of, of unsafe food and medications. We rely in the United States on the Food and Drug Administration to police, perhaps a suggestive term in this context, the marketplace for food and drugs. We know, of course, that whether a food is or drug is unsafe is sometimes contestable, either in gross, do this medication's side effects outweigh its benefits, or in particular, is this batch of lettuce contaminated? Administrative law provides the legal framework for addressing these and other questions. Begin with a standard example from administrative law. A meat inspector visits a butcher's warehouse and observes some items that in her judgment are contaminated. Without pausing to go to court, the inspector seizes the meat and closes the warehouse, pending a later determination by the FDA and ultimately by the courts that the meat was in fact contaminated. The FDA's determination will be subject to judicial review under the Administrative Procedure Act, and the reviewing court will accept any reasonable interpretation of the underlying food and drug laws on which the agency's actions rested, and accept the agency's findings of fact if they're supported by substantial evidence in the record as a whole. Now turn to counterterrorism policy. Like the meat inspector's actions, counterterrorism actions take place before the courts get involved. Decisions are made by experts in national security and processed through a bureaucracy both before and after action is taken. For example, the experts develop criteria for determining who can be properly targeted for covert action, and according to reports in the United States, high-level bureaucrats and political actors retain reasonably tight control over delegated authority to find that an individual fits the criteria. There are periodic reviews of the policy and its implementation, and revisions are made in light of experience. To that point, the decisions are quite similar to decisions made by typical administrative bureaucracies. What's lacking is some post-event evaluation by an independent judiciary, and that's a point that I'll return to. For now, note that under ordinary administrative law principles, reviewing courts in the United States rarely exercise their independent judgment about the propriety of administrative action, or here about specific actions taken pursuant to counterterrorism policy. The so-called Chevron doctrine provides the analytic structure. It directs the courts to proceed in 3 steps when they confront an agency's interpretation of a statute. First, in what's confusingly labeled Step 0, the courts ask whether the legislature gave the agency the authority to interpret the statute at all. The FDA may have been given authority over food and drugs, but its interpretation of statutes dealing with court procedure have no weight beyond that rationally accorded to the agency's reasoning itself. Next, in what's conventionally labeled Step 1, the courts ask whether Congress itself has resolved the question of interpretation. That is, whether the statute standing alone clearly requires the agency's action or prohibits its chosen course. If Congress hasn't resolved the question, the courts proceed to Step 2, in which they ask whether the agency's interpretation is a reasonable one. If it is reasonable, the courts are required to accept the agency's interpretation. There's one final step drawn from administrative law generally. The courts ask at the end whether the agency's application of its interpretation to the facts before it was arbitrary or capricious because, for example, the application rested on rationally irrelevant criteria, and whether the application was supported by substantial evidence. And here the courts evaluate specific actions in light of the entire record with a fair amount of deference to the agency's expert judgment about inferences to be drawn from fuzzy facts. Through these rules, the modern administrative state allocates the responsibility among Congress, agencies, and the courts based on our ideas about comparative institutional competence. The non-delegation doctrine and related doctrines say that Congress, not the FDA or other administrative agencies, has to make some decision, typically those of sufficiently large magnitude. And Congress's general authority allows it to make more detailed ones addressed in Chevron's first step. Those doctrines rest on the thought that Congress is directly responsible to the people. Administrative law charges agencies with making decisions that require a higher degree of technical expertise than is typically available to Congress, creating indirect political responsibility through agency attentiveness to congressional funding decisions and through the appointment of agencies headed by the President. The Administrative Procedure Act authorizes the courts to supervise agencies to ensure procedural regularity and minimal rationality, and the Constitution authorizes them to ensure that agencies' actions don't violate substantive constitutional rights. And again, the underlying theory is one of comparative institutional competence. Now, suppose we thought of the Departments of Defense and Domestic and Homeland Security as just another pair of administrative agencies charged with specialized tasks. Our thinking would have two components. One would deal with the court's regulation of these agencies. Like all agencies, they'd receive some degree of deference from the courts for decisions committed to them by Congress within their areas of expertise. The judicial role in ordinary administrative law is limited. The other would deal with the political branches, offering an explanation for the limited judicial role on the ground that political constraints on agency action are likely to keep them within lawful bounds. I'll turn next to an application of these ideas in counterterrorism policy.